The
recording,
so see here. So section number 13 we started yesterday. Alteration of memorandum of association. Alteration of memorandum of association. In that we completed subsection number 1. In that we completed subsection number 1. So, save as otherwise provided in section 61. Company may, by a special resolution after complying with the procedure specified in this section, alter the provisions of its memorandum. As I said in the yesterday's session, whenever the words save as provided comes, exception, generally alteration requires special resolution and conditions of section 13, except in case of section number 61. In case of section number 61, it will be talking about the concept of alteration of capital clause. For the capital clause alteration, all these provisions does not apply. That's the point you want to convey. That's section 13, subsection number 1. Next, any change in the name of a company shall be subject to the provisions of subsection 2 and 3 of section 4 and shall not have effect except with the approval of central government in writing. This also I completed. Whenever you want to make a change in the name of a company, name change should not be, the changed name should not be identical or too nearly resemble to the name of an existing company or a trademark, etc. All those things you need to follow again. Subsection 2, 1, okay. And proviso. I am changing the name. But what is the change in name? I am converting my public company into private company, or I am converting my private company into public company. The only change that has been made is the change in the limited and private limited, either adding limited in case of conversion of public to private, deleting private in case of conversion of private into public. That's the only change that has been made. In such cases, there is no requirement of central government approval, because that is a proviso inserted below subsection number 2, not a proviso inserted to subsection 1. No exception from the shareholders approval. Exception is given only from the central government approval, since there is nothing undesirable in that. Same name essentially is getting continued, just with an addition of PVT or a deletion of PVT. Hope everyone understood the point up to here clearly. Yes, sir. So we have completed section number 13, subsection number 1, subsection number 2, the proviso to subsection number 2. Next, please read subsection number 3. Start. Read, sir, everyone. When any change in the name of a company is made under subsection number 2, the registrar shall enter the new name in the register of companies in the place of old name and issue a fresh certificate of incorporation with the new name, and the change in the name shall be complete and effective only on issue of such certificate. This is the point saying about duty of ROC. Duty of ROC. This is the ROC's duty. So that's the duty of ROC. So whenever the ROC received the documents, I mean run form from the company to change the name, first thing is the duty number 1, enter new name. Duty number 1 is enter new name. Number 1, duty number 1. Next one, issue a fresh COI. This COE will be given in the old name with a changed name. Will be given in the changed name. Okay. Hello, completed everyone? What is the subsection we completed now? Subsection number 3. Okay. Now listen. Okay. See there. Please see the point. Read subsection number 10. Read. No alteration made under this section shall have any effect until it has been registered in accordance with the provisions of this section. Read again. Continue. No alteration made under this section shall have any effect. One second. Read again. No alteration made under this section. Listen. Please listen. Shall I continue? Listen. This is not effect. This is effect. This is affect. There is no effect concept in English. First point number 1. There is no concept of effect. Either there is effective. Effect means it is talking about a timing. Timing, coming into existence. With regard to that, the word effect will be used in English. Impact, influence will be discussed in the word called as affect. There is no in middle effect concept is not there. So please use the word properly and pronounce the word properly. The point is the word is not effect. What it is? Effect. Whenever E is there, it's called as a effective from. Effect. With effect from. It's not with the effect from. Point number 2. Affect. AFFECT talks about a impact. Say for example, Mr. A is affected by COVID. It influenced him or it contracted him. Like that we can tell. Okay. Exams will be conducted with effect from. Taking into existence. Coming into existence. Timing related. Hello, are you with me everyone? Yes, sir. So please read it properly again. Start. No alteration made under this section. That means it will not come into existence. You made an alteration, but that alteration will not take into existence, not come into existence until it has been registered in accordance with the provisions. Listen carefully. What do you mean by registered? Registration under this act must be done by whom? ROC. Registered represents ROC approval. Registration represents ROC approval. From this you need to understand. Shall we continue? Listen. Section number 13. Subsection number 1. Section number 13, subsection number 10. These 2 points are applicable for any alteration. I am not talking about name clause. In exams, if they ask a question on name change, objects change, situation change, capital change, any change if you have given in exam, 1, 10 common. Because one life you observe, he is talking about name, he is talking about any alteration. Everyone in the class. 10 also you read. No name alteration, no alteration. Not just name, any kind of alteration. Clear everyone in the class? Paste stick notes there. These are all certain important points that we need to understand and remember. Write down. Section 13 subsection 1, 13 brackets 1. Section 13(1). Section 13(1) and Section 13(10) and Section 13(10). Section 13(1) and Section 13(10) are common provisions applicable to all kinds of alterations. Applicable to all kinds of alterations. Okay. Section 13(1) and Section 13(10) shall apply to all kinds of alteration. That means it is not just a name clause change. Any change of any clause in memorandum, Section 13(1) to 10 are common provisions. Hello, I am talking to everyone. Yes, but one small issue which is not governed by section number 13(1) or 13(10) or entire section 13A. Point number 1. Tell me, whenever I want to change the name of a company, whose approval is required? ROC last. First, whose approval is required? Shareholders. By passing which resolution? Special resolution. Namaste. Tavasuprabhatam everyone. Most of the people are sleeping or not on this world, or their chip gone. You do one thing. Read the section. Then I will ask questions. Please. My bad luck is always I will see one face. That face I will tell wrong answer. Please read. Okay, completed? Now answer my question. Point number 1. Any alteration requires first whose approval? Answer. Next stage. Central government. After that you will file it with the ROC. Sorry. Shareholders will pass a special resolution and change the name of a company from some name XYZ to ABC. Special resolution required. But shareholders, how they have a right to change the name of a company? Idea of changing the name should come to whom? Board of directors, not to the shareholders. Always remember, in a company, I repeat once again, always remember, in case of a company, idea will be always made by the board of directors. Approvals will be given by the shareholders. Therefore, even when sections say or will not say, one point you should always write in examination. That's the first one I have written here in the charts. What is the first one? What is the approvals required? Number 1, board of directors. That will not be said, that's implied. It's a common sense point because shareholders don't take any decision. Shareholders are not decision making authorities. They are approving authorities. So therefore, the point is first who should approve that? Board of directors. Next will come to whom? Shareholders by passing a special resolution in a general meeting. Done. Next one. Then you will go to central government for its approval. Clear everyone? Done. But central government approval is not required. When the only change is addition or deletion of the words private at the time of conversion. Very good. Next, other compliances. Tell me, comply with section 4.2, section 4.3. I think everyone know what is 4.2 and 4.3 now. Next, comply with the procedures of section number 13. File the copy of special resolution altered memorandum with the ROC. ROC will make changes in the register of companies. That means it is registered. Once registered, he will issue a fresh certificate of incorporation. This is what we discussed in section number 13. Subsection number 1, subsection number 2, proviso, subsection number 3, subsection number 10, which is talking about the change in name. So, observe whether we have completed these or not. Done everyone? Shall we go to the next one? With this, we have completed the entire concept regarding the name clause. Perfectly, it is over. We will be now starting with the next topic called as registered office clause, also called as a situation clause popularly. Okay. See there. Situation clause, also known as registered office clause, also known as domicile clause. Part A. Please see there, how many parts are there? Let me first explain in the chart. After that, we will see the bare act. Part A, all about registered office. Okay. Section 4.1b, read with section number 12. Okay. After that, we will go to next area called as Part B, shifting of registered office. 2 pages. 3 sections will be there. All the 3 sections I merged in the form of this particular point. Clear everyone? Do you know what are all the sections? City to city, section 179, 12.4. Sorry, place to place within city. City to city, 179, 12.4, 12.5. ROC to ROC within the same state, 179, 12.4, 12.5, proviso and 12.6. State to state, section 179, 13.4, 13.5, 13.7. Clear? This is how the various sections will get attracted. Section numbers, everything I have written very clearly. Before going into them, see, this is the content we have to read. 2 pages we will complete the entire situation clause related content. Okay. So first one, please observe the section numbers I have clearly given here. What are the 2 sections we are going to start? 4.1b, section number 12. 2 topics are there, section 4.1b and section 12. Let's complete these 2 first. Okay. Please come to section 4, subsection 1, clause B. Come to the bare act, everyone. Read. I told you whenever there is a subclause, start from the beginning. Don't start from that directly. The memorandum of a company shall state the state. Shall state the state. This state is a verb. This state is a noun. Okay. Shall state the state in which registered office of the company is to be situated. That means in the registered office clause of MOA, we will write the name of the address of that particular company, or we will write the state. Answer. Why? Why not enter address clearly? Registered office clause means you should give the address of registered office. Under? Yes, that's what I am telling. You can enter into agreement and you can give that lease deed or rental deed. You can attach that and you can send. I said this logic in foundation, if you remember. Reasons also I told you at that time. Sir, okay, no problem in forgetting, but don't forget now. Point is, whenever we start a company once started becomes a separate distinct entity from that of its members and directors. Members and directors are different. Company is a different entity. This is a general tendency. What happens in a normal scenario? At a normal outset, generally company and members are treated as different persons. Once the company is incorporated, I will give you 1-2 examples for this. I first prepare MOA and AOA, then I will incorporate company. First I will incorporate company and then write MOA and AOA. First what will come? MOA, AOA will come first, or incorporation will come first? That means first we will prepare MOA and AOA. Later, on the basis of MOA and AOA, we will incorporate that particular company. Clear, everyone? Yes, that means by the time I am drafting MOA, company is incorporated or not yet incorporated? When company is not yet incorporated, under whose name you will enter into rental agreement or lease agreement? If company is incorporated, in the name of company you can enter. Yeah, understood or not? Yes, we will submit MOA, we will submit AOA, we will submit SPICE to ROC. ROC rejected here. What will happen? Your company will come into existence or will not come? Then, therefore, MOA preparation will not incorporate company. That MOA, AOA must be registered with ROC. He should register that, he should issue certificate of incorporation. Then a company will come into existence. Means, by the time we are preparing MOA, by the time we are preparing AOA, we don't know whether company will get incorporated or not. That means first what will prepare? Later what will come into existence? Means first what will come? Answer. Later what will come? Company incorporation will come into existence at a later stage after writing the MOA and AOA. Here lies the problem. When you prepare memorandum of association before incorporation, I repeat, when you prepare the MOA before incorporation of a particular company, okay, you don't know what will happen. Therefore, I can't write address exactly because company could not be in existence at the time I am entering into any agreement. For example, this building is there. I want to incorporate a company X Limited. I want to take this building on a rent. You are the landlord. I came to you. I asked, sir, I want this for a lease for 10 years. You said 5 crores or 10 crores, you said. Yes, sir, I am ready to pay. Please write a deed. He asked, in whose name? In my company name. What is the name of company? XYZ Limited. He asked, give the SIN number. Give the certificate of incorporation of the company. You said that, no, sir, it will be incorporated. In that name you give me now. Can I give a? Cannot give a. If you give, do you know what it will happen? That's called as deeds written in the name of a fictitious person. And that person is in existence or not in existence? In the name of a non-existent entity, you gave a lease deed, which becomes an offense under Transfer of Properties Act. Therefore, no fool will write deeds like that. Unless you give me certificate of incorporation, unless you give me the SIN number, no fool in world will write a lease deed in the name of a company. Clear, everyone? Yes, sir. Tell me, I am first drafting what? What is the second clause? What is the second clause? Situation clause. When I am writing company is incorporated or not yet incorporated? No, to be incorporated, incorporated or not yet incorporated? Existing or non-existent? Therefore, can you enter into any agreement or cannot enter into agreement? Then how can you write addresses? Therefore, the person who is drafting MOA will tell that I don't write anything, but I will mention the name of the state. Pakka it is Tamil Nadu, no doubt. But where it is, I will tell after incorporation. Clear or not, everyone? 100% it will be in state of Tamil Nadu. Exactly in Tamil Nadu. Tamil Nadu means very big state. There are so many cities, there are so many towns, there are so many municipalities, corporations are there. Where? I will tell you. Okay, after incorporation, I will tell you those details. That's why section number 12 came. That's why we are reading section 12 after this. 12 subsection 1 says that within 30 days, within 30 days of the incorporation date, you should intimate the ROC about the address of your registered office. Within how many days? 30 days. You should file a verification of RO. File a verification of RO, INC 22A form. You should file a verification to the ROC saying that, sir, As I promised, I will start a company in Tamil Nadu. I started. Where I started, if you have a doubt, in Chennai. In Chennai, if you have a doubt, Westmamalam, in that AGR road, this is a building number, this is a door number. I have started my company. If you want, you can verify. Like that, you will file INC 22A. Now, everyone understood the logic behind this concept. This is called as registered office setup, how it will be made under Companies Act. So, point number 1, registered office clause, I will mention the state, I will mention the place. State or place? State, with which the company is to be. The word to be represents what? Proposal. Lawmaker never does mistakes in writing languages. To be situated, because at the time you are drafting MOA, company is not yet incorporated. Therefore, he will use the word to be. Okay, shall we continue? Read again. The, not answering, everyone in the class. The state. The memorandum of a company shall state the state in which registered office of the company is to be situated. We are reading which section? Not number, content. Not number, content. Memorandum. We are reading which content? Memorandum. Memorandum will be drafted before incorporation or after incorporation? To be incorporated or already incorporated? Therefore, everything is future tense. Objects clause also. Proposed to be. This is all future tense section. Clear, everyone? Proposals, all are proposed, not yet finalized. Hope everyone understood the concept. I can go to the next one. Done. So, section number 4, subsection number 1, clause number B completed. If you remember yesterday I said, 4 section we can't read directly. One clause will be completed in each of the clauses here. 1 second, answer my question. What is the breakup of entire act section? Subsection, clause, stop there. Again. Once again. Very good. Now tell me, what is this section? What is this subsection? What is this A? Which clause? That's why it's called a name clause, situation clause. That's how the name came. Did you understand the concept? That's why these are called as clauses of memorandum, because those are all clauses inside this section. Therefore, people call them as a name clause, situation clause. Name doesn't come generally. There is a reasoning for that. So, because of insertion of clauses in section number 4, that name came. Sir, anyway, name clause, situation clause, objects clause, liability clause, like that clauses of memorandum came out. Hope you are understanding the concept, everyone. So, this section is talking about name clause, situation clause, all the clauses are. Yes. So, we completed 4.1a, 4.1b we completed. And we completed 4 subsection number 2, 3. Hello, I am talking to you. Yes, 4 completed, 5 completed. Okay, all these things are completed. Remaining last parts we have to complete, we will do that. So before going into that, 4.1a, 4.1b, everyone pakkana, shall we go to the next one? Yes, sir. Section number 12. See there, registered office of company. See there, registered office of a company. Registered office of a company. This section is exclusively registered office related section. Which section? Exclusively registered office. Situation clause ke exclusive section. Important for examination. 1 or 2 attempts only this was asked, not so great, easy only, but still tested in examination 2 times. So okay, let us see the concept. Registered office. First, point number 1. My question starts this way. Registered office clause means it will contain the place, location, state. Answer. State of Tamil Nadu. If I tell ROC want to inspect your company, now he will roam across Tamil Nadu state where XYZ Limited is there. So we have to give the complete details with the pin code, details, door number, company place, everything we need to give or not. About that, subsection number 1 will be talking about first. Okay na? Let's read. Start. A company shall within 30 days of its incorporation and at all the times thereafter have a registered office capable of receiving and acknowledging all communications and notices as may be addressed to it. You should only tell. I should have a registered office before incorporation or after incorporation? Within how many days? Within how many days? Read subsection number 2 also. The company shall furnish to the registrar verification of registered office. Everyone repeat, what is that? Verification of registered office. What do you mean verification of registered office? You will tell to ROC. ROC, I have given at that time state details only. I didn't give the location details. Now I am giving you location details also. If you want, you can come and verify. Read. The company shall furnish to the registrar verification of registered office within a period of 30 days of its incorporation in such manner as may be prescribed. Rules not applicable for examination on this section. All the rules are not applicable for exam. Only 7 rules are applicable out of 22 rules of this chapter. How many? 7 rules. 1 person company rules applicable, incorporation rules applicable, section 8 rules applicable, conversion of company rules applicable. Those rules are applicable. In this section, rules are not applicable for your exam. Okay. So tell me, within 30 days, I need to do 2 things. Number 1. Within 30 days, I need to do 2 things. I don't know what's wrong with you. Please read 1 and 2. Section number 12, subsection 1 and subsection 2. Take a minute time. Read yourself. Then only answer. Clear? Very good. Now tell me, what I have to do within 30 days? First you need to have a registered office. First to do that. First to do that work. Not just having RO. Once you have an RO, take a form called as a INC 22A. Not applicable for exam. If you want, you can write there. As may be prescribed means INC 22A. Form INC 22A you need to take. In that, they will give blocks. Door number, address, pin code, okay, secondary phone number, primary phone number, like that they will give details. You fill all those, file it with the MCA. That's all, over, done. That will be called as a verification of a registered office. Everyone understood or not? Yes, that you need to do within how many days again? 30 days. So within 30 days of incorporation, in this section I need to do 2 things. Number 1, have a registered office and file a verification of registered office with the ROC. Again, repeat for one last time. What I need to do within 30 days? have a registered office, file a verification of registered office within a period of how many days? 30 days of the date of its incorporation. Shall I ask a question on this now? Yes, listen carefully. Once you say yes, be committed on that. Now I will ask that. No worry. When I say I ask question, until and unless something is there, that first I will not ask and waste my time. Okay? See the screen. My company got incorporated on 1/1/22. Example sake. Take a simplicity of an example. 1/1/22 my company got incorporated. I need to file within a period of how many days? 30 days. Means my last date for filing will be 31/22 or it will be 31/1/22 is a question. Don't get excited. Listen. First point number 1. Within 30 days of, not from. Within 30 days of, not from. Within 30 days from the date of incorporation, from the incorporation data, of the incorporation data. This is a question. So, first point number 1, when I say, please answer a question, if nothing is there, I will not ask my time, I will not ask the questions and waste my time. Answer. See first. Great people tell 31. When I say no, answer is 30. I said 30, 31. If I said 31, I said 31. Overaction. That's why option A na bina you tell, don't act smart. People will tell option A, 31 they will tell. No, I will tell not this one. Yes sir, I said 31. A na B na? Option A na B na? Answer here everyone. First point number 1. Option A or option B? Abhi. A na B na? Sir. Now tell me how many of you are thinking that it is option A? A. If I ask a question why means no one will have an answer. Tell me why. So confidently you raise hand. Off. Like this it has to go. Okay. Sorry. Okay. Next. Anyone? Why you are thinking that it will be starting on the date of 1/1? So, point is, you will have an apprehension that maybe this or this. Some opinion will be there. But that opinion should not have a weakness. That should not be shaky. You should have a clear opinion on what you say now. In court you stand. At that time, why means you should not just give him an overall opinion. It should be having a strong base, substantial evidence to prove your allegations. So how is it possible? Is a query now. Whenever in any act, of from is used, how to interpret them? General Clauses Act, section number 9 of GCA, there in our syllabus. General Clauses Act is there in our syllabus or not? Yes, sir. Very good. Just wait. I will show you directly. Tell me the name of the act. General Clauses Act. Okay. Please read General Clauses Act section number 9. Start. Not reading. Stop there. Start again. In any central, okay, it's not visible. In any central act or regulation made. Stop there. Companies Act is a statewide act or central act? Pakka. Made after the commencement of this act. Okay, 2013 is after 1887. It shall be sufficient for the purpose of first, excluding the first, in the series of days or any other period of time, to use the word from. Whenever you use, fatal, whenever you use the word from will always exclude the first day in a series. Of will include the first day as well. That means answer will be 30/1. Abba, you also don't know any idea. It's only random clicks. So the point is, answer is 30 January. Abba. Answer is 30th January is the correct answer. Okay? Because whenever the word from is used, whenever the word, then only you should exclude the series of days la first day. Clear? In a series of days, the first day should be excluded when you are using the word from. From today. Whenever you are reading the GST Act, Income Tax Act, Section 234 ABC in Income Tax Advance Tax, interest calculation on day basis, at that time, you must remember one very, very important point. From of you need to check properly. On that basis only number of days will be calculated. If you do from interpretation as of interpretation as from, 72 days will become 73 days sometimes, 73 will become 72 sometimes. Clear? So this is the interpretation of the term from and of. Everyone understood the concept clearly? Very good, sir. This is the point I want to tell. At least now did you realize why General Clauses Act is there? Yeah, in order to interpret these kind of general words in English. At the time it will be used. Sorry, okay, everyone. Now, we got an idea what to read now. Tell me, everyone in the class, a company shall within 30 days from offer. Tell me, my company got incorporated on 1/1. I should count 30 days, including the data, excluding the data. Including the date of incorporation, we need to count it. Please paste the stick notes there, write down. Right on there. As per section 9 of the General Clauses Act, as per section 9 of the General Clauses Act, as per section 9 of General Clauses Act, whenever the law uses the word whenever the law uses the word of, whenever the law uses the word of, whenever the law uses the word of, it shall include the first day in the series. It shall include the first day in a series. It shall include a first day in the series. Clear? Full stop, continue. If a company is incorporated on, if a company is incorporated on one 22, if a company is incorporated on 1/1/22, 1/1/22, verification form shall be filed within verification form shall be filed within 30 days of 1/1/22, within 30 days of 1/1/22, which is 30th January 2022. Which is 30th January 2022. Sir, everyone understood the point number 1? Everyone in the class? Yes, so 1, 2, both are completed now. So please tell me, within 30 days of incorporation, I need to do 2 things. Number 1. Second one, file a verification of registered office. So please tell me, ROC has to verify the registered office of the company within how many days of its incorporation? Wrong answer. ROC need not verify. He can verify at any time. Game over. Read again. We have to file. He need not verify. Good morning, everyone. Good morning. Very good morning. Please read properly. Okay, now can I go to the next one? Okay. You have to file verification within 30 days. ROC has to verify within 30 days. That's all. You should file. Whether he verify or not, none of our business. And moreover, in every 10,000, 15,000 companies, one company he will verify. Okay. He has so many works. He will go for verification of registered offices, where you are spy agent. So therefore, they are not so much concentrated enough to go for companies verifications, register office. If they have any doubt of something going wrong, then they may make a verification. In general terms, they will not. But your duty is to file a verification of register office within a period of 30 days of its incorporation. Clear, everyone? Done. So we completed section 12.1 and section 12.2. Now let us come to section number 12.3. Please see that. Every company shall, number 1. Read. Every company shall paint or affix its name and the address of its registered office and keep the same painted or affixed on the outside of every office or place in which its business is carried on, in a conspicuous position, in legible letters, and if the characters employed therefore are not those of the language or one of the languages in general use in that locality, also in the characters of that language or one or more of those languages. Every company shall have its name engraved in legible letters on its seal, if any. Every company shall get its name, address of registered office and corporate identity number, along with the telephone number, fax number if any, email, website address if any, printed in all its business letters, bill heads, letter papers, and in all its notices and other official publications, and have its name printed on hundies, promissory notes, bills of exchange, and such other documents as may be prescribed, provided that where a company has changed its name or names during the last 2 years, it shall paint or affix or print, as the case may be, along with its name, the former name or names so changed during the last 2 years, as required under clauses A and C. Provided further that the words one person company shall be mentioned in the brackets below the name of such company wherever its name is printed, affixed or engraved. Stop. Understood up to here clearly? Same what he is talking about. Subsection 3 is talking about disclosures. Take 2 minutes time. Dead easy concept, just a procedure. So please read it properly first. Take 2-3 minutes time, no problem. I should not see anyone sitting idle in the class. Please, once I call on to the stage, please. I should not listen any mistakes. Please read the points clearly. Completed? Hello everyone, completed? Literally see here once. A, B, C and D. 4 points are there if you observe here. 4 types of disclosures are there. What are these 4 disclosures? Let us understand first. I will explain. First see. Every company should disclose certain things. Say for example, this is a registered office. Say for example, AGR building is there here. That's a registered office building. That's why outside there will be a very big board. Lighting board will be there. On that board, what details will be given? First, name is visible or not? Yes, a person moving on the road, when he see the board on the left side of the particular building, he can easily recognize that this is an academy. Name is clear or not, everyone? Yes, that's called as conspicuous position. Conspicuous position means board is kept on the road, board is kept towards the classes. On the road it will be kept. That means persons moving on the road should see it, not the students who come inside. Clear, everyone? Yes, say for example, imagine the building. This building you imagine. Entrance will be there on this side. Yes or no? Yes, road is on this side. Okay? Now I kept the board to this wall. Who will see? No one can see that. That's not conspicuous position. Just for a reason you are just putting the board. Board, when you put the name, address, everything must be clearly mentioned on the board. Either you paint on the wall, you paint the address clearly. No painting, sir, that's a old fashion. Then at least affix its name. Affixing means board. You affix it like KS Academy, what it has done. That's as per the rule, therefore they have done. Or else small board is enough, but it is not permitted. Companies Act makes it mandatory. KSA Educational Services Private Limited or not? Yes, and a company or not? Yes, every company must follow Companies Act. There is no option available. Okay? So, first point, it should be in a conspicuous position. Clear? Next, legible letters. Which letters? Legible letters. Legible letters means it should be clear. Font should be clear. It's called as a legible letters. When you use that particular words, it should be clear. It should be catchy to the people. When you go on the road, if you see the board of KS Academy, is it clear or unclear? Very clear. Font size, color, whatever they have kept, it catches the eye. Okay, this is called as KS Academy, some educational institute. Everyone can understand and they see. That's what law want to convey. Your company should not be a hidden secret company. Let the public know that there is a company like this. Therefore, the point is very clear. Whenever you start a registered office, how that registered office should be? Outside the place of business of the registered office, you can either paint, you can either affix. What you have to paint and affix, everyone? Name. KS Academy name is there or not? Yes. Address of registered office, it is there or not? That's all. Name and address. First case, name and address. And keep the same. Painted or affixed on outside of every office or place in which it carries on business. Sir, tell me, that's a head office or not? Yes, answer here. Yes, this is a branch. Sir, branch can be far away branch, it can be nearby branch, anything. Here also they are carrying on their own business or not? Yes, sir. On this building also, that's why board will be there. It's a mandatory as per Companies Act. Are you understanding the point or not? No, sir, they are carrying on business at some other place. Then there also you have to. There also you have to. Clear everyone in the class? Sir? So there also you have to. Wherever you carry on your business, you have to. Some or the other how people should understand that this is KS Academy. Clear everyone? Now tell me what we have to do. Either paint. You know I will not leave until you answer. So there is no other way around. And I am not a PDF reader. Just I will read. Have you understood? Before you tell no, okay, I will go to next concept. We will not go. Until and unless you answer to my satisfaction. So answer my question. Point number 1. What is the section we are reading? 12. 12 which subsection? 3. 3 how many clauses? 4. A, B, C, D. A what we have to disclose? Name and address of what? Registered office. Where? Every place where you carry on the business. It may be either painted or it can be either affixed on outside every place of business. Which position it should be? Conspicuous position. Which letters it should be? Legible letters. Next. Sir, if the characters are used in Hindi, say example. Hindi is not a spoken language here. Person who started company may belong to a state where Hindi may be his language. Say for example, a person is from Gujarat, Rajasthan, etc. Person language is Tamil, original language is Hindi. Maybe he kept a board in Hindi. But persons in this locality can understand Hindi, may not understand. In all cases may not. 1 or 2 persons can understand, but every person on road can't understand. If you use in any language which could not be understood by the locality, you must also use the language that is being used in that locality. You put in Hindi, no problem. But what he is asking is, one of those language also in the characters of that language, not only. You use Hindi board, use it, no problem. We are not denying that. You can use. But along with that, use also an English board such that everyone can understand. Or use a Tamil board, everyone can understand. Here. Clear, everyone in the class? That's all. That's the language. Idea is very clear. If it is in English, no problem, because it is accepted everywhere in India. That's why always we will see which boards. English board, because if it is a company, normal firms, sole proprietor concerns, LLPs means no problem. If it is a company, these problems will come. Companies can't use any local language directly. Must and should they will use English, because everyone should understand it. Okay? So, paint or affix. Once read subsection number 3, clause A. For my satisfaction sake, everyone read it out. Every company shall paint or affix its name and address of its registered office, and keep the same painted and affixed on outside of every place or every office or place in which its business is carried on, in a conspicuous position, in legible letters, and if the characters employed therefore are not of those language or one of the languages in general use in that locality, also in the characters of that language or one of those languages. So simply it should be in a local vernacular language. Pakka. One should be local. Sir, I don't want any local, sir. Then write in English. English is a safe bet. No one will ask you the question. Clear, everyone? 12 subsection 3 A is completed. Please read clause B. Start, everyone. Every company shall have its name engraved in legible letters on its seal, if any. So now tell me. Seal means stamp. Official stamp will be there. Whenever you see the stamp, if you see the stamp and if you put it down on top, if you see, you will see the letters coming out of the rubber stamp. That's called as a engraved. Engraved means letters will be embossed outside. The embossing will be done outside. That means the letters will come out like a 3D effect, it will come out. Letter. That's called as a engrave. Sir, grave means what? Grave. Grave means a big hole. It's called as a grave. If you see the engraved stamp, there will be ups and downs in that. So that's called as a engraving. On a rubber stamp, they will engrave the symbol or engrave your name, engrave your address. Everything they will engrave and give. So stamp la affixing, painting, printing will not be there. Seal will be having a engraved. So therefore use the words properly. Have its name engraved in legible letters on its seal. Observation number 1. Tell me. Point number 1. Outside every place of business, what I need to disclose? On the seal, what I need to disclose? Name only. Seal, that much space will not be available to write your address. Are you in this world, everyone? When I tell board, affixing, painting the boards, then what you need to write? Name and address. Stamp, what you need to write? Name only. Observation number 1. Clear? Lastly, we will write one stick notes to write all the observations that we made on this section. Number 3, C point. Please read. Get its name, address, SIN, telephone number, fax number, email, website, on all business letters, bill heads, letter papers, etc. On documents, not just name, not just registered office. You need to give complete detail. Whenever you see any bill given, on the top letterhead, they will write name, address, telephone number, fax number, mobile number, everything they will give because of this reason. Are you understanding the point or not? You see the bill given by Case Academy, the invoice it is given, not just a name and address will be given. What they will give? Name, address, their telephone number, fax number, phone number, mobile number, email address, website address, everything they will give. That not their generosity. It is a mandate as per Companies Act. Clear everyone in the class? Now tell me three things we completed. Number one, name and address. Second one, name only. Third one, name, address and other details. Clear everyone? Those should be given in the documents, business letters, bill heads, letter papers, publications, notices, etc. Last, have its name printed on hundis, promissory notes, bills of exchange and other such documents. Or about this we will see in an act called as a Negotiable Instruments Act very clearly. As of now, remember, negotiable instruments. About the hundis, promissory notes, bills of exchange, checks, etc. Everything I will discuss in detail in a chapter called as the Negotiable Instruments Act 1881. When we come there, I will discuss about that. Not today. It takes a lot of time. I think you know about bills of exchange, kada? Yes. In foundation also it is there. Then you will be having a clarity on what is a bill of exchange. Sir, okay. First point number one. Tell me, sir, how many points we completed in this? I am talking about subsection 3A. How many points are there? 4. Number one, ask about what? Very good. Second one, only name. Third one, name, address and other details. 4, only name. Clear everyone? In the charts form, if you see, you will get more clarity on this. Please. Please read this. All about the registered office. Please read, sir. Contents. First, state where the company is to be situated. Very good. Next, registered office and rules with respect to RO. First, establishment of RO within. Verification of RO. File with ROC. I am very clear about this. You have to verify within 30 days. Filing should be done within 30 days. Filing should be done within 30 days. Whether he verify or not, irrelevant. Okay. Next, other issue. Disclosure with respect to the name, etc. What are the disclosures? How many? See here. This is a branch. How many branches are there to this? 4. We took reasonable care to make the charts more and more appealing in nature. Name, etc. details. First, I have made it into 4 blocks. A, B, C and D. Okay, start. A. Not print. Paint or affix. Start. Paint or affix. Details. What details you need to affix? Address of registered office. Where? Mode. Language. Now how easy it will be. Same section, same content, same subclass, same clause. We have broken that into 4 equal parts. So first one is the details, name and address, place, outside every place, mode, conspicuous and legible letters. Fourth, language is local language. He didn't use the word called as any local language, means it's not Tamil, Telugu, etc. Locally, whatever can be understandable, you can use that. English is understandable in the locality or not? And moreover, this board should be understandable by the students. Can they read the board or not? That's all. That's how we need to interpret. Beggar going on the road who don't know any language, I can't convince him with any language. So therefore, everyone need not understand that language. Who really get affected by this, if he can understand this particular board enough, law will be having a acceptance. Okay, see there. Next, continue. Name engraved on the seal. No side headings for that, nothing. Next, print. What it has to print? Details of. Sir, on the paper we can't paint. On the paper you can't affix. On the paper you can't engrave. Therefore, the word used is print. So ensure that you are writing perfectly. Read. Print. Print what? Details. What details? Name, address, SIN, phone number, fax, email, website. Where? On all kinds of business letters, invoices, bill heads, notices and official publication. Last one. Print. Details. What the? Name of the company. Where? On all negotiable instruments. This is how the charts have been made. Everyone understood the point clearly up to here? So this is the end of section number 12. Completely we didn't do it. We have completed section number 12, subsection number 1, 2 and 3. Main concepts are over. Okay. Na? Next. Come to the other parts of section number 12. Provisos, you put it on hold. First read subsection number 4. Notice of every change in situation. Stop there. That's why I asked you to read. Now we are going to read situation clause. Change in situation. Therefore, all changes in situation clause we will read in one set. Okay. 12.4 is talking about change. 5 talking about change. 6 talking about change. 7 talking about change. 8, 9 talking about overaction. If you do contravention, what will happen? Okay, na? Next. After 12, what is the section? 13. 13 will be talking about what? Alteration. So now we are going in a next world in itself. Change in the registered office. What is that? Change in the registered office. Very, 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 very important for examination. At least 15 times it is tested. From the old to new companies act put together. Easily 15 times. If I am not wrong, it will be more than 15. I am taking a conservatively taking 15. Very, very important. Bits it can come. 2 marks it can come. 4 marks it can come. 6 marks possibility is also there. Very, very important topic in this particular area. What is the area concept? Change in the registered office. Sorry. First point number 1. Section numbers let us know. After that you do whatever you want to. Tell me what is a part B in the charts material. Shifting of registered office. Okay. First, what are the 4 types of shifting? Let us know. See the screen, everyone. What are the 4 types of shifting? 1 second. Everyone, please. Are you in this world? Yes, start. What is the first type? To place within the city. Next, city to city within the state. Next one, ROC to ROC within state. State to state. One state to another state transfer. These are the 4 types. First, understood the idea, na? First one, place to place within the city. Next, city to city within the state. ROC to ROC within the state. State to state changes. These are the 4 types. Understood up to here? On this we need to understand which sections. Let us see. 12.4, 12.4.5, 12.4.5 proviso and 12.6. After the 13.4, 13.5 and 13.7. Clear? If you remember 13.1, 13.10 common. Separately you need not write for registered office concept. I told you just 45 minutes back. 13.1, 13.10. It is common. Common for what? Common for any change. So separately I need not write here. It is a common point for all changes. Okay. So we have to first read 12.4, 12.5 and 12.6 and its proviso. Let us see what they are. Come to section number 12 now. Continue. 12.4, 5, 6. Read. 12.4, 5, 6. Let us read. Notice of every change of situation of registered office verified in a manner prescribed after the date of incorporation of company shall be given to the registrar within 30 days of change, who shall record the same. Except on authority of special resolution passed by a company, the registered office of the company shall not be changed. In case of an existing company outside the local limits of any city, town or a village where such office is situated at the commencement of this act, or where it may be situated later by virtue of a special resolution passed by the company, and in case of any other company outside the local limits of any city, town or village where such office is first situated, and where it may be situated later by virtue of special resolution passed by the company, provided that no company shall change the place of its registered office from the jurisdiction of one registrar to the jurisdiction of another registrar within the same state, unless such a change is confirmed by the RD on an application made in this behalf by the company in the prescribed manner. Next, the confirmation referred to in subsection 5 shall be communicated within a period of 30 days from the date of receipt of application by regional director to the company, and the company shall file the confirmation with the registrar within period of 60 days of date of confirmation, who shall register the same and certify the registration within a period of 30 days from the date of filing such confirmation. Stop there. First read subsection number 4, 5 and 6. Take 2-3 minutes time. I should not see anyone sitting idle in the class, please. Read means please read properly. Completed reading, everyone? Answer. First, point number 1. Tell me, I want to shift my registered office from one place to another place within the same city. What is the subsection governing it? Tell me, I want to change from, say for example, I want to change from Veshmambalam to, say for example, Adayar. I want to change. Tell me, I need to comply with what? 5 will apply or not? Will not apply, because it will apply only for outside the local limits of any city. Entire time given wasted. It is applicable only if the change of registered office is from the outside the local limits of a city. I am going from, say for example, Chennai to Coimbatore, shifting the registered office. In that case, you can utilize that subsection number 5, no doubt. Are you understanding or not? I am shifting from here, from Chennai to Madurai, I am shifting. At that time, you can use it, no problem, no doubt, you can use it now. So the point is, when you are going outside the local limits of a city, or a town or a village where originally the registered office is situated, then subsection number 5 will get attracted. Sir, irrelevance of A and B, main point is special resolution required. That's what you want to convey. Hello everyone. I want to change from ROC to ROC, or from state to state, or from city to another place. Clear? It requires which resolution? Answer. Here a small amount of common sense is required. That common sense is, when I tell, if you shift the registered office outside the local limits of a city, special resolution is required. When you change the state, automatically city changes. When you change ROC, automatically city changes. Therefore, in all cases, it may be a change from city to city, ROC to ROC, state to state. One common provision is applicable in all cases. What is that? Special resolution is required. Everyone up to here understood? Yes, but the idea of changing this registered office should start to whom? That's implied always. I told you in the previous section or not? So tell me, what is the step 1? Take the approval of Board of Directors. Next, take the approval of shareholders by passing a special resolution in a general meeting. Done. Very good. 2 points over. Up to here, everyone understood? Yes, now the question starts. Sir, I want to change not outside the local limit, sir. From Veshmambalam to Adayar, I want to change. Both are in the same city, Chennai. Clear or not, everyone? Yes, so now what to do? So places will be there in Hyderabad. There are 2 areas are there. Both the areas adjacent. Jubilee Hills, Banjara Hills. Both are adjacent areas. I want to shift from Banjara Hills to Jubilee Hills. So I want to change the place, one place to another place. 5 to 10 kilometers difference will be there. I want to change. And I want to change from here, from Veshmambalam to Adayar, or Veshmambalam to some other area. If I want to change like that, it is a same city, but the places are changing. In that case, special resolution not required, because there is no shift of registered office from local limits of the city. Then what is required? Board of Directors approval only. Whose approval is only required? Board of Directors approval only. That's why they didn't write anywhere in the section about change from the place to place within city. They didn't write. Why? It requires whose approval? Board of Directors approval. Board of Directors approval is dealt by section number 179, which is not there in our syllabus as well. But generally in exam you write down board approval is required in all cases. After that, shareholders by passing a special resolution. Now everyone of in the class should answer. I want to shift from place to place within city. Step 1. Board of. Step 2. I need to do anything? Yes, yes and yes. You need to follow with subsection number 4. You should tell ROC that you are changing your RO. Or else how he will understand? Refile INC 22A. That's why he used the word verified. Again, you should file verification of registered office. 5 minutes you have taken. I don't know what you have done. Whenever you change your registered office, sir, I changed from, as I said, Veshmambalam to Adayar I changed. In the records of ROC, which place is there? Now I change it to what? How he will know? That's why you have to file again. Did you understand the point or not, everyone? If you don't fail, how would I know that you changed your registered office? Okay, na? Therefore, this is common. That's why he used the word every change. Not change from anything, any change. It can be place to place, city to city, ROC to ROC, state to state, any change. Any change you make, na, inform me. Inform me in a verified manner. INC 22A is a verification form. File that. First point, everyone tell me, understood or not? Yes, sir. Tell me, I want to change register office from place to place within city. Step 1. Step 2, verification. Over. Next, I want to change from city to city within the same state. Tell me, step 1. Board of Directors. Step 2, shareholders by passing a special resolution in a general meeting. Step 3, verification. Done. Again, ROC to ROC within same state. Board of Directors, special resolution, RD confirmation. You had read, na, regional director. RD confirmation. Time limits, everything we will see in the next class. Just summarize, let us understand. RD confirmation. And lastly, verification. State to state also same process. Discussing will be made in the next session. Along with the compliance of section 13, verification should be made under section number 12.4. Hope everyone understood the logic of 12.4. 12.4 is applicable for every change of registered office. It can be place to place within city, city to city within same state, ROC to ROC within the same state, state to state change. Remaining concepts we will see in the next session, but one small point we will close. Point is, sir, ROC to ROC within same state means can a state have two ROCs? Sir? Only two states are having two ROCs. One is state of Maharashtra and the other state of Tamil Nadu. In foundation also I said this point. Two states are having two ROCs. State number 1 is Maharashtra. State 2 is the Tamil Nadu state. That concept came not today. That concept came in 1951. 1951 onwards, Tamil Nadu state is having two ROCs. Reason is very clear. At the time, Andhra and Madras used to be combined states. Andhra and Madras used to be combined state. When it is a combined state, it is the first biggest state in entire India. Biggest state. What happened? Madras and Andhra both used to have a common state. 1951 time. After that, the division was made on a political basis. Though people here in this area, if you see, even after 50, 60 years, people here in coordinators, whoever work here, speak in Telugu. For one good reason. It has its legacy continued even after 70 years, 80 years, because originated people didn't shift to Andhra. They are still having their existence in the state of Tamil Nadu, because once upon a time both the states are merged together. At the time, ancestral people used to have their existence in Madras state. At the time, Andhra Pradesh, Hyderabad, all these used to be part of one state called as a state of Madras, which is decided by the British when they left India. Most of the companies, whether started by people in Andhra, started by people in Tamil Nadu or leave off, all the companies' head office used to be Madras state, because British headquarters it has become. Therefore, Madras state used to, Madras place, exactly the city of Madras, happens to be the head office for most of the companies. 50 to 53 time, a division happened. After happening of a division, they asked two things. Tamil Nadu, do you want Chennai or Tirupati? Is a question. They asked two things. Sri Ramulu in Andhra Pradesh and persons in Tamil Nadu, only two questions happened. Do you want Chennai or do you want Tirupati? Only one. If you want Chennai, you take Chennai, give Tirupati to Andhra Pradesh. If you want Tirupati, give Chennai to Andhra Pradesh. Like that problem happened. Matter went to the central government. They thought that they have Hyderabad, na? We want one city like that. These people asked. They have Hyderabad city. Okay. Therefore, you do one thing. You give me a city. Let them take it. So after that, when division happened, state of Tamil Nadu was divided from the state of Andhra Pradesh. Politically, they divided them on the basis of linguistic basis. They divided the state. At the time of state division, they said, let Tirupati taken by state of Andhra Pradesh. So many people in Tirupati also speak in Tamil for that reason. It has that effect always. So many people in Madras used to speak Telugu. That effect is also there. So this is the reason. Both the states once upon a time are jiggery. After that, on a political basis, they divided. Technically, people are not divided. This is not India-Pakistan war. Technically, those are not divided. But still, political basis, they divide on the basis of a language. They divided. Let's divide both the states. In 1953, division happened for the state. After that, you know what has happened. It has divided. Tamil Nadu has become. Therefore, what happened? Most of the companies of persons belonging to Andhra Pradesh are also having headquarters in Madras. For 20 years, 30 years, 40 years, if I have a register office here, suddenly because of state division, why I will turn to other place? Therefore, they made here itself. Therefore, that two overseas concept still they continued here only. There are cements like Andhra Cements, head office is in Chennai. KCP Cements, head office is in Chennai. Okay. Andhra Sugars is such a company where it will supply the rocket fuel. Rocket fuel will be there to launch a rocket. Ignition fuel is required. That ignition fuel is given by that. Head office is in Chennai. Persons are from Andhra Pradesh. That's called as Andhra Sugars. You can check on Google as well. They will supply the rocket fuel. Ignition fuel they will supply. From the sugarcane it will be extracted. So, like that, so many companies which are having. So, number of companies are very high here because of that combined effect. Clear, everyone? It continued like that. Okay. Later, what happened is one great person became Chief Minister of Tamil Nadu. His name is Annadurai. One great person has become Chief Minister of Tamil Nadu. At that time, what happened is 300 to 350 kilometers of state of Tamil Nadu was declared as a special economic zone by the government of India. It happened way back in 1970s. Okay, 1960s, 70s time, CES recognition came for the state of Tamil Nadu. State of Tamil Nadu recognized as a CES. CES means what? It should be away from a local limits. Urban limits ke away it should be. I should develop that place. Therefore, what they have chosen? Madurai to Chennai. I should have an industrial belt. CES recognition came. That's called as a special status given to the state. After division happened. So at that time, great development has happened in industrial side. That's why so many industries are there here. Manufacturing hub. So many manufacturing hubs are there in state of Tamil Nadu. Tamil Nadu state is having highest manufacturing after Noida in India. So Noida means obvious. When entire central politics and drama happened in center, obviously place around that will develop. But the surprise is, down bottom a place like Chennai, Tamil Nadu is getting developed means it is only because of your state's initiative. So if state doesn't take an initiative, it will not develop, obviously. Simple reason. Noida developed means no surprise. Noida is what? It is a tail of Delhi. No surprise if it get developed. Gurgaon, Noida, if they are getting developed, there is no surprise. Obviously it will be developed here. Capital city, adjacent cities, if they don't develop, Tupukkan central government. So it will be developed. But the surprise is down south states are developed. That's the greatness of that state governments. So undoubtedly, cities like Chennai, cities like Hyderabad, cities like Bangalore, if they are developed and they are competing with the cities like Delhi, Bombay, means it's only because of state government, because center never supported states. And it will never. Center never support, at least south states. They will never support it. They will never give any funding. This funding, everything is your parents, our parents, their taxes, their money only developed the states. Central has given, but support is never given to states. They always try to make their political party to come to state, rule in the state. People are kicking with the left leg in Andhra already. So they will not let, because when state divisions happen, development they should concentrate. They concentrate on politics rather than on development. States only developed themselves. Chief ministers who worked for Tamil Nadu, who worked for Andhra Pradesh, they only have done their service. Because of that, state was developed. So today, if it becomes a manufacturing hub, today Hyderabad is becoming a Silicon Valley, just because of the chief ministers who worked in those states. So those people have done. Likewise, when the companies are very heavy company load is there. Madras at that time, 1950, they applied. After Companies Act came, old Companies Act I'm talking about, they applied for 2 ROCs. One in Madras at that time, one in Coimbatore. Coimbatore is also a very big manufacturing hub. trading, all these things happen heavily in Coimbatore as well. So therefore they have done. Coimbatore one ROC is, Chennai one ROC is there. 2 ROCs totally. Maharashtra also have 2 ROCs. Maharashtra having 2 ROCs is also not a surprise. Maharashtra is a hub of total commercial existence in India. It's a commercial capital. Clear? No surprise if it have 2 ROCs. Okay, it has a ROC. State of Tamil Nadu have 2 ROCs now. Therefore, what they have done, one ROC is then extra ROC. He will do the work of an RD in Tamil Nadu. Later, what happened? State of Andhra Pradesh, Hyderabad has become one of the crown for that. Companies came, thousands and thousands of companies started. Later, what they thought, let us have 2 ROCs. Andhra Pradesh also kept a proposal. Okay, Rajshekhar Reddy, when he is the Chief Minister of Andhra Pradesh. So he kept that we want 2 ROCs. Heavy load is there. Listed companies are growing like anything. Because never in India type companies are there. First Microsoft started there. Okay. Therefore what they have done, let us have 2 ROCs here. Load is very high. Therefore government said that we don't give an ROC, but we will do one thing. We will give an RD to you. Clear or not everyone? We will give RD. Workload is heavy na. You take RD. Instead of having an ROC na, you have a very big person than ROC. We will give one ROC, one RD to that state. In all other states, there is only one ROC. Kerala, Karnataka, Orissa, Madhya Pradesh, Gujarat. You take any other state, 4 states are only having this privilege. One Andhra Pradesh, second Tamil Nadu, third Delhi, Delhi, and the 4th one is Maharashtra. These are the states who are having the RDs and ROCs together. Clear? Here there are 2 ROCs. There is ROC RD combination. Mumbai, Maharashtra, there is ROC and RD. No surprise here. It's very big. So therefore this is how the divisions have happened. Now in the next session what we are going to discuss is if I want to change my register office from Chennai to Coimbatore. Are you understanding or not? How? What is the procedure? What to do? What we have to do? To whom we should apply? And what is the time limits of all those? That's what we are going to discuss in the next session in this regard. Clear everyone in the class? So thank you very much. We'll see you in the next session.